The Law of Domicile. Chapter 1. Introduction. Section 1. Municipal Organization of the Roman World. We are indebted to the civil law for both the term domicile and the legal idea which it represents. The organization and polity of the Roman world were preeminently municipal. In its early history we find Rome, itself a walled city, having an organization and institutions suitable to the requirements of municipal life, surrounded by numerous independent states, composed in their turn either of single cities or confederations of cities. As these fell one by one under the sway of their ambitious and insatiate neighbor, either by treaty or conquest, they experienced treatment differing according to circumstances. Some, becoming allies, merely or mainly recognized the military hegemony of Rome, and retained, at least for a time, their independence in other or most other respects. Some, upon being beaten in war, were allowed to a large degree their autonomy, retaining in some cases their ancient constitutions and the power to choose their own magistrates, etc., and enact their own laws, while in other cases new bodies of laws were imposed, or the power of selecting magistrates was denied, etc. Again, some of the conquered cities were depopulated in whole or in part, and had introduced into them colonies, bringing with them new constitutions modeled usually after that of Rome itself. Various subsequent changes took place from time to time in the constitutions of many of these cities, voluntarily in some cases, and in others in consequence of internal disorders or open revolts against Rome, and changes also occurred in the relations with that city of themselves and their citizens, new privileges being conferred in some cases, and in others existing privileges being withdrawn or restricted. And doubtless, too, there was constantly going on a gradual assimilation in the main between the constitutions of the various cities. Without entering into these matters in detail, and without stopping to discuss the consequences of the Lex Julia Municipalis, which conferred the jus civitatis upon all Italians, it is sufficient to say that these cities, or urban communities, as they are sometimes aptly called, bore the common name of civitates or respublics, and included two general classes, municipia and colony, under which were several subordinate classes, such as civitates fundane, prefectures, etc. Each urban community possessing a more or less independent constitution, with its own magistrates, having jurisdiction, and even with power, more or less limited, of making its own laws. To each town was attached a district called territorium or sometimes regio. At the time of the complete development of the Roman constitution, towards the close of the Republic and during the first centuries of the Empire, as Savini points out, the whole soil of Italy outside of the city of Rome was included in these urban communities, and every inhabitant of Italy belonged either to the city of Rome or to one or other of these urban communities. The provinces, on the contrary, had originally very various constitutions. They had, however, gradually approximated to the municipal system of Italy, although in them this system was not carried out so completely and thoroughly. In the time of the great jurists, in the 2nd and 3rd centuries of our era, the proposition just now laid down in regard to Italy could almost be applied to the whole empire. The soil of the empire was almost entirely included in distinct urban territories, and the inhabitants of the empire appertained either to the city of Rome or to one or other urban community. Section 2. Arrigo and Domicilium. The Roman law recognized two kinds of connection between a person and an urban community, namely, citizenship, generally called Arrigo, and domicile, Domicilium. While a discussion of the former does not fall directly within the scope of this work, it is necessary to state briefly its general features, inasmuch as without such statement it is impossible to arrive at any clear conception of domicile under the Roman law. Those who possessed citizenship in an urban community were usually designated as municipies, or sometimes as cives, while in color were those who were domiciled within the urban territory. Section 3. Id. Arrigo. Citizenship arose in four ways: first, by birth; second, by adoption; third, by manumission; and fourth, by election, or formal admission by the magistracy. Municipum aut nativitas facit, aut manumitio, aut adoptio, cives quaedam Arrigo, manumitio, electio, vel adoptio, incolas viro. Domicilium facit. First, by birth. This was nativitas or Arrigo in its restricted sense. But inasmuch as it described the most usual mode of acquisition of citizenship, the term Arrigo was commonly employed as a generic term to designate the civic relation however arising. A legitimate child usually followed the citizenship of his father, and whether such child at birth acquired citizenship in a particular place depended upon whether his father had citizenship there. The exception to this general rule arose in a few cases where, by special privilege conferred upon certain cities, women belonging to them transmitted their citizenship to their legitimate children, and it is not clear from the texts which have come down to us whether in such case the child took citizenship only in the native town of his mother or in both places. This exception is of little importance to us beyond this, that it conclusively demonstrates that the citizenship of the parent and not the domicile, which in the case of a married woman was always that of her husband, was the basis upon which the jus origines of the child rested. Illegitimate children acquired by Arrigo citizenship in the town to which the mother belonged. Second, by adoption. Adoption conferred a cumulative citizenship upon the adopted person. For while he retained his former citizenship with all its incidents, he gained also that of his adoptive father. And this double citizenship was transmitted also to the children of the adopted son. But as this anomalous condition of cumulative citizenship began with and depended upon the artificial relation created by adoption, so it ceased upon the destruction of that relation by emancipation. Third, by manumission. The freedman by manumission acquired citizenship in the native town of his patron. 10. And this also descended to his children. If the patron had citizenship in several places, or if the common slave of several masters were manumitted by them, then a plural citizenship might arise by manumission. But only by complete manumission was thus acquired citizenship which imperfect manumission did not confer. Fourth, by election. The last mode of acquiring citizenship was by election. This subject is involved in much obscurity. It has been thought by some that this was not a distinct mode, but that electio is only another name for adoptio. Cujas cites from manuscripts, without however approving, a reading of the text contained in the code different from that given above, namely, electio, id est, adoptio, and some color has been given to this reading by the entire omission of electio in the text contained in the digest. But it is not usually accepted, and although authority in the Roman law sources is wanting, Savini holds that by electio is to be understood the free gift of citizenship by the municipal magistrates, of the legality of which there could be no doubt even if it were not expressly attested. Without authority it certainly seems reasonable that the power to admit citizens must have rested somewhere in the civic body, but by whom it was to be exercised, in what manner, or on what conditions, we have not the grounds even for conjecture. Section 4. Id. By whichever of these means citizenship arose, it could not be extinguished by the mere will of the person, but, as Savini points out, except in the case of citizenship arising from adoption, which as we have seen ceased with emancipation, dismission by the municipal authorities must have been as necessary as election by them. A legal marriage, while it did not destroy the Arrigo of the wife even if it were different from that of her husband, suspended during her marriage her liability to personal burdens connected with her native citizenship, and a similar immunity from personal burdens without the complete dissolution of his original citizenship applied in the cases of a citizen raised to the dignity of a senator, and his children, and a soldier during the period of his service. It is apparent, from what has already been said, that a person might at the same time possess citizenship in several urban communities, and so too it was possible that in several cases he might be without citizenship in any. Section 5. Domicilium. The second bond or connection which the Roman law recognized between person and place was domicilium. It differed from Arrigo in that it was of a less artificial character and generally depended solely upon the will of the person, so that, generally speaking, without the consent of the municipal authorities one might acquire and abandon domicile at pleasure, provided that his intention to do so was accompanied by the fact of transfer of bodily presence. It is not proposed here to enter into an inquiry concerning the Roman theory of domicile, inasmuch as it will be noticed incidentally in various parts of the body of this work. For the present the learned reader is referred to the principal texts contained in the Code and Digest, which are collected below in a note. It is sufficient to say that although it differs in some points from the modern theory, there is a general correspondence, and more particularly with the modern theory as held by the continental jurists, than whom the British and American authorities have taken a somewhat wider departure from the Roman theory in several particulars. Section 6. Arrigo not domicile of origin. In these two ways, therefore, a person might belong to an urban community. Enough has been said to show that Arrigo, whether that word be used in its generic or specific sense, and domicilium differ widely in their constitution, and particularly that the former in the Roman law did not correspond with what is now termed domicile of origin, as is erroneously supposed by some good writers in modern times, and as was apparently assumed by some of the older continental writers, who in other respects seem to have correctly apprehended the Roman doctrine of Arrigo. Section 7. Consequences of Arrigo and Domicilium. The consequences of such connection were threefold. First, liability to share municipal burdens. Second, the duty of obedience to municipal magistrates, and particularly the personal jurisdiction arising therefrom. And third, subjection to the special municipal law, applicable to an individual as a personal quality. Section 8. Id. A. Subjection to municipal burdens. First, whatever rights may have been derived from the connection of a person with a particular place, they were the result of citizenship, Arrigo, alone, and not of domicile, for domicile was dependent upon the will of the individual, and it is not to be supposed that municipal rights could be obtained without the consent of the municipal authorities. But even such rights as citizenship conferred, however valuable they may have been at first, in course of time grew to be very insignificant, while on the other hand the municipal burdens to which both municipes and insular were subject grew to be very grievous, and especially so were the duties and responsibilities incident to the decurionatis, or municipal office. But the obligation to undertake these and other municipal burdens rested upon all the members of the municipality, whether they entered into the relation by Arrigo or domicile. It was particularly in consequence of the oppressive nature of these burdens, which were constantly sought to be evaded, that the subjects of Arrigo and domicile were much discussed, and many texts have come down to us. Section 9. Id. 6. Subjection to local magistrates, parum. Second, it was a general principle of the Roman law that every lawsuit must be brought in the forum of the defendant and not in that of the plaintiff, and a forum was imputed to each individual in every town, whose magistrates he was bound to obey by reason of his belonging to such town. But as he belonged thus to every town in which he had Arrigo or Domicilium, it follows that Arrigo and Domicilium determined the forum of the defendant, and hence the place where every lawsuit must be brought. Where, however, one had Arrigo and Domicilium in different places, the place to which he belonged by Arrigo was doubtless usually resorted to as the forum only in case he happened to be found there, and as he could be more easily and conveniently reached in the place of his domicile, it is probable that that place was usually resorted to. This is probably the explanation of the fact that in the texts relating to jurisdiction domicile is more frequently referred to than Arrigo. Section 10. Id. C. Personal law. Third, with reference to the third consequence of the connection of a person with an urban community mentioned above, much is left to conjecture, as few texts which have any bearing on the subject have come down to us. There is enough, however, as Savini acutely demonstrates, to show that in certain cases, at least, the territorial law applicable to an individual as a personal quality was determined by his citizenship if he had any. If he had citizenship in several communities, that learned jurist contends, his citizenship by birth determined in preference to that subsequently acquired by adoption or election, and if he had Arrigo in no place, his domicile necessarily must have been resorted to. The last hypothesis, however, bar combats upon the ground that the particular law of an individual was considered to be privilegium, either odiosum or favorabile, as the case might be, of his status, and therefore that it is obviously absurd to hold that a person by changing his domicile according to his own pleasure could have acquired such a privilegium of status. Section 11. Transition to modern law. All of the consequences above enumerated of connection between person and place have survived to our times. To what extent will be briefly outlined in the succeeding chapter. For this historical account the first two may be dropped, and the third, namely, subjection to territorial law as a personal quality, briefly followed. Section 12. Id. Personal law. Several principles more or less distinct have in different times and countries been resorted to for the purpose of determining the personal law applicable to an individual, namely, citizenship, or, as it has appeared in recent times, political nationality, race descent, and domicile. Besides citizenship as we have already contemplated it, in its restricted sense, namely, municipal citizenship, or Arrigo, there was in the Roman law a citizenship higher and having a wider scope, which did not always accompany the lower and more restricted form. For until the time of Caracalla a municeps, or citizen of an urban community, was not necessarily a civis Romanus. Roman citizenship carried with it the adherence to the individual who possessed it of a particular law, that is, the jus civilis, as the personal quality, which clothed him with rights and capacities which those who did not possess it were denied. How far the status conferred by Roman citizenship might have been modified by the possession of jus origin is in an urban community having particular local laws, is by no means clear. Barr holds that with the universal extension of citizenship by Caracalla, the particular system ceased, but this is denied by Savini. Section 13. Id. Race descent. But citizenship, of whichever aspect, as a test and determinant of the personal law of an individual, after a while gave way before a new principle, and was almost entirely lost sight of until it was revived in quite recent times. The principle referred to was nationality or race descent, and was carried to its utmost extent during the wandering and early settlement of the Teutonic tribes, immediately before and after the fall of the Roman Empire. Having no settled abode, but wandering about from place to place, a member of such tribe could not be looked upon as connected with any particular place by any tie. He was looked upon as a Lombard, a Burgundian, or a Frank, and judged as such and not as a citizen or an inhabitant of this or that particular place. And even when these wanderers, after having overrun and conquered different parts of the Roman Empire, had become settled in permanent seats, they did not for a long time become fused with the inhabitants of the conquered provinces, but conqueror and conquered remained distinct, each race retaining its own laws, so that there were often found in the same district several distinct systems of jurisprudence administered to different portions of the inhabitants in accordance with their respective nationalities. Thus the Frank was judged by the Salic or Ripuari code, and the Gaul by that of Theodosius, and even in the same city Roman, Lombard, Frank, Burgundian, and Goth might all be found, each living under his own personal law. But with the rise of the feudal system we note the decline of this principle. The cornerstone of that system was territorial sovereignty, and hence its policy was to fuse all the inhabitants of the particular territorial division into one mass, to strike out all distinctions depending on national descent, and to substitute strict territoriality. This was the general rule, although there were particular instances in which a contrary policy was to a certain extent followed, as for example in the case of England after the Norman conquest. Though the distinction between Norman and Saxon was for many years kept up, although it was mainly political and penal in its character. A trace of this principle of national descent has come down to more modern times in the disabilities imposed upon the Jews in various countries, as well as in the allowance to that people of certain peculiar laws relating to marriage and kindred subjects usually cognizable in the ecclesiastical courts. The rise of free cities and the growth of municipal institutions also contributed largely to the desuetude of the principle of national descent. But, as is pointed out by Savini, the influence of Christianity, the advance of civilization, and the more varied and active intercourse between different nations have removed the rougher contrasts of nationalities, and thrown their characteristic differences more and more into the background, so that the principle of nationality as a test and determinant of civil status has been for the most part eliminated from modern law. But not entirely, for it is still applied in the cases of European merchants resident in Eastern countries, where, in the language of Lord Stowell, an immiscible character is kept up. Foreigners are not admitted into the general body and mass of the society of the nation, they continue strangers and sojourners, as all their fathers were. It is also applied in Eastern countries, not only to Europeans residing there, but also among natives belonging to different races, for example in Turkey and India, and to some degree it is applied in this country in the case of the North American Indians. Section 14. Id. Local laws and customs. But feudal system, besides fusing the different traces dwelling within a given territory, and therefore rendering impossible the application of race descent for the determination of personal law, had done another thing. It had broken up continental Europe into a vast number of petty sovereignties exercising authority more or less independent over territories each possessing its own customary law, and had thus rendered possible, in course of time, the rehabilitation of the old Roman principle of domicile. The vast number of legal territories into which the soil of continental Europe was split up seems at this day almost incredible. France, where the feudal system flourished most vigorously, was divided in the first instance into the pays de droit écrit and the pays de droit coutumier, and the latter in its turn into many legal territories, so that prior to the adoption of the Code Napoleon the number of local customs exceeded 300, and according to Monnoyer, the customs were so diverse that one was not able to find in the Kingdom of France two châtelleniers which in every case used one and the same custom. The rise of free cities contributed to the same result. Gerardus Corselius writes to Burgundius that there were as many different sets of laws in the Netherlands as there were cities. In Germany this state of things was carried to the extent of dividing sometimes the same township or city into several local customs. Thus there coexisted in Breslau until Jan. 1, 1840, 5 different particular laws and observances in regard to succession, the property of spouses, etc., and the application of which was limited to certain territorial jurisdictions. Not unfrequently the law varied from house to house, and it even happened that one house was situated on the borders of different laws, to each of which, therefore, it belonged in part. Section 15. Id. Real and personal statutes. Return to domicile. The necessity for some uniform principle for the application of these local laws to constantly recurring legal relations early became apparent, and the doctrine of real and personal statutes was invented with domicile as the basis of the application of the latter. Hence domicile came to be discussed to a large extent by the continental jurists, and to be frequently used for the settlement of conflicts of local laws. Section 16. Id. Codification and political nationality. In recent times codification has in most European countries stricken out local customs, and replaced them with uniform national laws, and the field of the conflict of laws has therefore become largely international instead of domestic, as it originally was. Moreover, several European nations have by positive legislation discarded the principle of domicile in the determination of private international questions, and substituted for it the principle of citizenship or political nationality. Domicile has in those countries thus ceased to have the importance which it once had, although it is still resorted to for the settlement of many questions of municipal law. While, therefore, its discussion is omitted from many of the recent European treatises on private international law, it is contained in many of the works on municipal law, notably in the numerous explications of the French Code. Section 17. Domicile in British Jurisprudence. Turning now to Great Britain, we find that the notion of domicile is of quite recent introduction into the jurisprudence of the countries composing that realm. Indeed, it is asserted that the word itself, so little was it known, did not find its way into English dictionaries until about a half-century ago, although it was used by the courts much earlier. Chief Baron Pollock, speaking in 1864, says, "It is somewhat remarkable that domicile is now very frequently the subject of discussion in our courts, and as we have more than once observed, the word is comparatively entirely new to the English law, for neither it nor the notion it conveys belongs to anything English. The word domicile is not to be found in Viner's abridgment, Bacon's abridgment, Comyn's Digest, or in English law books from Bracton down to Blackstone. To the same effect is the remark of Lord Campbell in Thompson v. The Advocate General, 1845, "The truth is, my lords, that the doctrine of domicile has sprung up in this country very recently, and that neither the legislature nor the judges, until within a few years, thought very much of it." Section 18. Id. Early English cases. The principle of domicile seems to have first made its appearance in both England and Scotland in cases of personal succession. Perhaps Sir Leoline Jenkins was the first English lawyer to use the term. In the reign of Charles II, He speaks of it as a term not vulgarly known, but holds that the lex domicilii furnishes the correct rule for the distribution of the personal property of deceased persons. Almost a century elapsed after this before the subject was brought to the notice of the courts, at least in any reported cases. But in Pipon v. Pipon, 1744, and Thorne v. Watkins, 1750, Lord Hardwicke laid down the law with great positiveness and clearness, holding, in accordance with the now universally received doctrine, that personal property must be distributed according to the law of the decedent's domicile. It is to be observed, however, that while this doctrine was clearly set forth, the term domicile was not used by his lordship in either of these cases. The question does not appear to have again arisen until in the case of Kilpatrick v. Kilpatrick, 1787, at the rolls before Sir Lloyd, afterward Lord Kenyon, who decided it upon the same principles as those relied on by Lord Hardwicke. It is surprising that the different customs prevailing in the provinces of York and Canterbury did not early give rise to the application of the principle of domicile in cases of personal succession. But in 1801, while the case of Somerville v. Somerville was before him, Sir Richard Pepper Arden directed search for cases in which it had been applied to be made in the Spiritual Court and the Court of Chancery, with the result that no such case could be discovered. Section 18a id. Early Scotch cases. Contemporary with the case of Pipon v. Pipon in England was the case of Brown v. Brown, 1744, in Scotland, in which the Court of Session confirmed the decision of the commissaries of Edinburgh, who had decided that the deceased, Captain Brown, was origine a Scotsman, and never had any proper or fixed domicile elsewhere, and that therefore the succession to said Captain Brown's movable estate is to be regulated by the laws of Scotland, a recognition of domicile both in principle and in name. In a number of cases before and after this one, however, a contrary view was held, and in Morris v. Wright, 1785, the Court of Session declared it to be firmly fixed that the lex loci ought to be the rule, and further observed that the doctrine of the case of Brown v. Brown was exploded by the most eminent lawyers of the time. So widely did the Scotch courts differ from those of England and from the jurists of the continent. It required, therefore, several decisions of the House of Lords to put the question at rest and settle the law of Scotland upon this point in accordance with that of other civilized countries. Section 19, id. Bruce v. Bruce and its sequents. The first of these cases, Bruce v. Bruce, came upon appeal from Scotland in 1790, and was argued at the bar of the House of Lords by advocates of great celebrity, Sir John Scott, afterwards Lord Eldon, and William Alexander, afterwards Lord Chief Baron, being on one side, and Sir Riley Campbell and Charles Hope, both afterwards presidents of the Court of Session, on the other. The Court of Session had decided, first, that the decedent Major Bruce, whose domicile of origin was Scotch, being in the service of the East India Company, had his domicile in India, that is, by fiction of law, or at least in legal effect, in the province of Canterbury, and second, that as his effects were all either in England or in India, distribution must be in accordance with the law of England, the locus recite. Lord Thurlow, in his opinion delivered at the time of giving judgment in the appeal, went into a discussion of the grounds of the judgment of affirmance which was pronounced, saying that the true ground upon which the cause turned was the deceased being domiciled in India, and that therefore the law of England furnished the correct rule of distribution, not because it was the lex loci recite, but because it was the lex domicilii. This case has ever since been held to have fixed the law of Scotland upon this subject, on the basis of the law of nations. The judgment, however, having been simply an affirmance of the decision of the Court of Session, and nothing else appearing upon the record, as the case appears in the Scotch report, its grounds might be misapprehended but for the fortunate preservation of a stenographic report of Lord Thurlow's speech. This celebrated case having been followed in the House of Lords and Court of Chancery during the next 5 or 6 years by the equally celebrated cases of Hogg v. Lashley, Balfour v. Scott, Omani v. Bingham, Bimpt v. Johnston, and others, in which not only was the principle of domicile applied, but its nature and grounds discussed, the attention of the profession in both countries was attracted to the subject, and thenceforward cases involving the principle became numerous. Section 20. Domicile in American Jurisprudence. In America the subject of domicile was first discussed in the case of Guyer v. O'Daniel, decided in 1806 in the Court of Common Pleas of Philadelphia County and reported in a note to the case of Spatz v. Buckwier. The opinion delivered by Rush, President Judge, recognized and followed the law laid down in Bruce v. Bruce, and the case has ever since been looked upon as a leading one. Like the earlier cases in England and Scotland, it involved the question of the distribution of the personal estate of a decedent. And as in those countries, so in this, the principle, once having been recognized, was quickly appreciated by the profession and applied to the determination of cases involving a great variety of questions. Section 21. The division of the United States into a great number of quasi-independent states, the vast colonial possessions of Great Britain, the increased and increasing value of personal property, and the greater freedom of migration brought about by improved means of locomotion, have rendered cases involving the principle of domicile of frequent occurrence in those countries. The most powerful minds in the profession on both sides of the Atlantic have been applied to the consideration of the subject, and notwithstanding the occasional conflicts of opinion upon particular points, the general principles of the law of domicile have been explicated with considerable clearness, and a system has been built up differing in some respects from the doctrine of the Roman jurisconsults and the modern civilians. Between the British and American authorities, however, there is, except in a few particulars, a close correspondence, brought about in great part, we are glad to believe, by the influence of the writings of that eminent judge and accomplished jurist, Judge Story. Section 22. Bibliography. There are in the English language but 3 substantive treatises upon the law of domicile. First, The Law of Domicile, by Robert Phillimore, advocate in Doctors' Commons, and barrister of the Middle Temple, London, 1847. Reprinted in the Law Library, Philadelphia, 1847. This a work of great learning and industry, in which are collected, perhaps, all the English cases decided up to that time, together with some of the American cases and with copious references to foreign authorities. An appendix contains extracts relating to the subject of domicile from the writings of Menicius, Mascadas, Pothier, Bunkerschuek, and Cochin, and from the French and Sardinian codes, together with the judgments in the leading cases of Bruce v. Bruce, Bimpt v. Johnston, Somerville v. Somerville, and Guyer v. O'Daniel. Altogether it is a very valuable book, and has always been cited with the greatest respect. This work was subsequently incorporated bodily, and with scarcely any additions, in the 4th volume of the work by the same author on international law, which has run through several editions, the 2nd edition of the 4th volume appearing in 1874. It is to be regretted that this learned author and distinguished judge did not see proper to rewrite his exposition of this subject, in view of the large number of cases which had appeared in the interim, or at least to incorporate the most important of them into the body of his text. Second, a treatise on the English law of domicile, by Oliver Stephen Round, Esquire, of Lincoln's Inn, Barrister at Law, London, 1861, 16 Mo, pp. 124. This does not pretend to be either an exhaustive or an accurate treatise, but was written, as the preface tells us, chiefly in vacation, without the aid of books, but of notes only collected at spare moments. The aim of the author seems to have been rather to touch upon every branch of the subject than either to collect all the cases or to weave them into a systematic exposition. The work is but little known, and is to be found in but few libraries in America. It has been cited in only several English cases, and does not seem to be relied upon as an authority. Third, the law of domicile as a branch of the law of England, stated in the form of rules, by A. V. Dicey, B.C. L., Barrister at Law, and formerly Fellow of Trinity College, Oxford, London, 1879. This is a clear and systematic discussion of the subject exclusively from the standpoint of an English lawyer, and notwithstanding the almost entire absence from it of any notice of American cases, the work is a valuable one to American lawyers because, among other reasons, of its excellent analysis of fundamental notions. The author does not, however, limit himself to the consideration of domicile per se, but devotes more than one half of his space to an examination into its legal effects. His work is thus substantially a treatise on the conflict of laws from the standpoint of domicile. Another work may be here mentioned, although it considers but a narrow branch of our subject, namely, a treatise on the domicile of Englishmen in France, by Henry W. Cole, London, 1857. It collects and discusses with clearness and ability the authorities, both French and English, which had appeared up to the date of its publication upon the subject of the acquisition of domicile by foreigners in France. The author appears to have had some special qualification by reason of his experience in litigation involving the subject matter of his treatise, and although this might be supposed to bias somewhat his opinions and to detract from his judgment while adding to his information, yet his statements are fair, and his conclusions are given without apparent partisanship. Section 23. Each of the several treatises in the English language on the conflict of laws or private international law contains a chapter on domicile. The earliest, with the exception of Henry on Foreign Law 1 and Livermore on the Contrariety of Laws, which is indeed in size only a tract, and, although containing much that is suggestive, is neither a full nor a systematic exposition of the subject of the conflict of laws, is Mr. Justice Story's Commentaries on the Conflict of Laws, which originally appeared in 1834, and has run through 8 editions. Chapter 3 is devoted to a discussion of national domicile, and is by far the most lucid exposition of the subject in the English language. It has done more than any other work to bring into harmony the decisions of the courts on the subject, and in a large proportion of the cases on both sides of the Atlantic has been cited and relied upon by both counsel and court. Owing, however, to the plan of the work, it was possible only to state conclusions and refer to authorities, without entering into any minute discussions. 4 years later appeared, in England, William Berg's Learned Commentaries on Foreign and Colonial Law, in 4 large volumes. This work is a great storehouse of profound and accurate information upon the subject expressed in the title. It is unfortunately inaccessible to most American lawyers. Chapter 2 discusses the subject of domicile with great learning and ability, in the light of the foreign authorities principally. Following this in England were the treatises of Westlake, Phillimore, and Foote on private international law, in each of which the subject of domicile has been separately considered. And in this country has appeared the well-known work of Dr. Wharton on the conflict of laws, which has passed through several editions, and which also devotes considerable space to the discussion of our subject. To these may be added the English translation by Guthrie of Savini's volume on the conflict of laws, where the subject of domicile is considered at some length, with the historical and exegetical accuracy and learning which characterizes the writings of that prince of modern jurists. This list may be still further increased by adding a large number of works on special subjects to which the principle of domicile is more or less applicable. Particular mention, however, should not be omitted of the excellent collection of English and American authorities and discussion of the subject contained in the first volume of Hare and Wallace's American Leading Cases. Section 24. Among the works of continental writers treating solely or largely of domicile may be mentioned Lauterbuch's Dissertatio de Domicilio, and Thomasius' Tractatio de Vagabundo, and in French, Desquion's Traité du Domicile et Absence, and the several theses Paula Doctorat, of Ansel, Charvans, Ramsel, and Berfongorfia. The subject is discussed at greater or less length by many of the older as well as later continental writers. A list of the most important is given below.